This and the following sequel video clips could serve as blueprints for fighting those responsible trying to privatize or steal the very air we breathe. It's no exaggeration that this is a struggle for survival, an ongoing global grassroots movement with our future hanging in the balance. And if you won't fight for yourself, then fight for your children. They are among the most vulnerable to the toxins these self-serving politicians, conspiring with, aiding and abetting their greedy corporate benefactors who would do us the most harm, visit upon the community while selling the very air we breathe. Share this information. Many don't know how critical this tipping point has become.
And they're pretty much, it's not like it's a central point of your case. It's just in case the judge wants to look at one element of the charge.
Please rise. The Spirit of the State of Washington. Roman County Basin is now in session. The Honorable Christine Pomeroy presiding. Please be seated.
I have a petition. Let's just go through it and introduce all of ourselves. I know some do, some I don't. I have the petition that was filed. I have a declaration of Jay Hupp. I have the declaration of Charles Hauser III. I have a supplemental brief in opposition of the petition for recall. I have a response in opposition to a petition for the recall, and I have a reply to response in opposition to petition for recall. And I also have the prosecutor's statements outlining the facts in this case. I think that's what I'll call it. Okay? All right. Is there something that I don't have?
Yes, Your Honor. Brenda Donkers for Mr. Boucher, who was responsible for submitting the petition. And I'd like to, in response to the respondent's most recent filing, provide the court with some supporting documentation. Now, this is information that is not in any way different from what was already filed. It's better organized in an attempt to show the court which documents were submitted in connection to which allegations. And there was a technical change to allegations 1 and 2 that we're submitting that correct what the subject of the motion at issue in allegation 1 was. And so we have those documents. We submitted them to opposing counsel, and I'd just like to present those to the court.
Counsel? Mr. Meyer?
I have no objection to this supplemental or reorganized material. It was the attachments to the original petition.
All right.
And there's some highlighted areas And this, Your Honor.
Have you had a copy?
Yes, I do.
Okay, thank you.
Thank you.
All right, is there anything else that I don't have?
Not on behalf of the county.
Your Honor, did you get the CD, the DVD that was attached to the petition?
I have 4
Okay.
DVDs, and let me just tell you what I do have. June 1st, testimony 2010. August 3rd and August 16th, September 1st and September 21st. Those are the DVDs I have. They were submitted.
And to explain the projector, we have copies of those in case you would like to refer to them or view them in any way, as well as one of the emails refers to a video that was sent as an attachment called the Intabulator video. That's the start of the Intabulator video if you care to watch that as well.
I'm inclined to get this started, and so I'm going to turn first to the prosecutor's office. The prosecutor has stated the facts, but anything else, Mr. Cobb, on behalf of the county?
No, Your Honor. As we've been through before on previous such petitions with myself and Your Honor, the state's position in this is effectively as a scribe, and we have completed our statutory requirements. We take no position as a county as to the recall's merits one way or the other.
All right. All right, then I'll turn to the petition, and your name again, sir?
Brendan Donkers, Your Honor.
Mr. Donkers?
Yeah.
Donkers, you are the attorney for the petitioners, and I've got the petition here that alleges a committed. Okay, so I'm just going to call you counsel. Okay? Mr. Donkers, I'm going to let you go forward as to why I should grant it. Remember what the criteria is there a factual or legal sufficiency? That's what we're looking for. I'm not going to try this case. And so I'm going to let you talk. Then I'm going to come back, and Mr. Meyer, you are representing
Commissioner
Mr.
Jay Hupp.
Hupp. And I do have also a declaration by Mr. Hauser, who I assume was the attorney from some of the pleadings in here, was the attorney for the port. Is that correct?
That's correct.
All right. You're ready.
Yeah, Your Honor, before we begin, I'd like to clarify how much time you would like us to spend. I ask because I want to make sure we have a chance for a rebuttal, if the court would entertain that, and would like to know if the court is interested in hearing additionally from Mr. Brochet or some of the folks that drafted the
No,
petition.
I am not interested in taking testimony. I'm going to tell you that right now. This is an entirely different ballgame. We don't take testimony. We have declarations, and unless there are declarations, I am not considering them. You may go ahead, counsel.
Thank you. Well, as the court pointed out, there are very narrow issues in front of it today. A lot of folks are here that have been involved in an issue that is outside of this pleading and pleading in this issue, and we're obviously not here to discuss that. What is in front of the court is the very narrow issues of the petition sufficiency, factual sufficiency, and legal sufficiency. And if you look into the RCW 2956, which outlines this process and what the court is reviewing today, it's pretty sparse. But the case law has been very clear in describing what a low hurdle a citizen activist has in describing the petition, so the facts that are alleged, factual sufficiency, along with showing the conduct that is deemed to be either misfeasance, malfeasance, or a violation of oath of duty.
I'm going to stop you. I actually know the statute.
Okay.
I actually have read the statute. I want you to address whether or not the allegations, and I think there was one about destruction. Just go through those.
Okay.
On this day, this is it. This is what we have. Here's an affidavit to this. That's what I want you to do, okay?
Great.
I appreciate it.
So allegation number 1 discusses a motion that was in front of the commission, and it was a motion to, I believe the motion was to preserve tape records. It was to preserve audio recording of the court's meeting minutes. Now, the vote that was taken was a vote, I believe, from,
And that was in June 2010 meeting?
that's right,
Thank you.
and it was a motion by Commissioner Miles to preserve these records, and my understanding is that Commissioner Hupp and Commissioner Waltner voted against that motion. The petitioner cited the allegation, RCW, that prevents the destruction of records. They think there's, although there's no allegation that in the first one, that the records were actually constructed and that the law was therefore not violated, remind the court that it's not just a standard of malfeasance that the court's looking at, but improper conduct. So our petitioners are rooted in this first allegation in the motion that was rejected.
Okay, but the trouble is, and this is what I'm going to tell you, the motion was given, it was voted one way or another. How is that malfeasance? How is that misfeasance? That's what I want to ask you.
Sure, my understanding of malfeasance, of course, requires some proving of violation of law. And so, in this case, or in this allegation, misfeasance, I would say apply, improper functioning performance of duties. Talking about the destruction of public records when there is a questionable legal basis. Again, not a clear legal basis, but a questionable legal basis. Our petitioners are asserting wrongful conduct.
In the responding briefs that I have before me, they are saying that on this vote, he may have voted anyway, but that nothing occurred, and that another vote in July voted to preserve this for 6 years.
So allegation 2 gets to your second point about what happened in July, and what that was is from the petitioner's perspective, it was an attempt to cover up the subject of the June 1st meeting. So again, the improper conduct is the fact that what is at issue in front of the commission is whether they're going to destroy evidence that the state auditor has instructed them, and we submitted this also with our materials. This is one of the issues that the state auditor suggested the court commission provide some more focus and detail on. Make sure that these records are not destructive. So in light of the auditor's report, in light of the discussion, we think that constitutes misfeasance. And I'll direct the court to some of the case law that we cited. We cited the case of West, where the Supreme Court of the state found it sufficient that he sent an unsolicited and improper email to a prospective intern. It wasn't based on the fact that he had violated a law. It was improper conduct. Of course, different facts, not drawing a parallel to what occurred in that case, but showing that you don't need to break the law. There are very easy, the statute is written in favor of petitioners being able to submit this to the public. And in light of the auditor's report for those first allegations saying take care of your records, petitioners have been very upset about that. They feel that this, along with some of the other allegations that I can now proceed into, but this is a larger course of conduct that is preventing the citizens from being engaged in this decision. So I can proceed to allegation 3.
Yes, go ahead. So the first 1 and 2, what I hear you saying is that his vote taken at a meeting is the basis, and it's a general type basis. It's
Taken as a whole, case law saying take all these allegations as a whole.
okay. Thank you. Appreciate it. Okay. Go ahead.
And-
Number 3.
Okay. So allegation 3 is a series of emails that went back and forth between Commissioner Hupp and one example is Commissioner Hupp and Commissioner. I believe one of these was with Commissioner Walton, right?
Yeah, there was
Walton.
another commissioner involved.
Yeah, and Commissioner Miles was not included in some of these emails, and we think that fits within the OPMA, the Open Public Meetings Act, because of how broadly action is defined. It includes the discussion of official business, and what the subject of some of these meals, we're talking about citing the facility, citing this new proposed facility, and this is one of the activities that is certainly in connection with whether